All right, people, we're going to do this. We're going to make this work. Done is better than perfect. I think I can get this done. I told my wife I was going to the bathroom, so that buys me at least 12 minutes. We're going to go over the Trump Colorado ruling today. I've taken screen grabs. Yesterday was the everyone calm the hell down. It doesn't say what the newspaper is saying it says. Trump has not been excluded from the ballot in Colorado, as if that would make a difference because Colorado is as blue a state as the ocean. It doesn't matter. It's the principle that matters in all of this. Yesterday, told everyone to take a deep breath, calm down. Trump is not off the ballot. The court order itself, because it's so novel, revolutionary, and I dare say communist, even the 4 commie judges agreed to stay their own court order until January 4th and then pending adjudication by the Supreme Court of the United States. Fine. Okay. I read the decision now. I read the decision and the dissents. A lot of people are saying, oh, this court out of Colorado is 7 Democrat-appointed judges, partial as hell, biased as hell. You're right. But bear in mind, even as a 7 appointed Democrat judges on this court, it was still a split decision 4-3. You read the dissenting opinions of the dissenting judges who are Democrats as well, and they are saying in their dissenting opinions, I can't believe that this is what justice in America looks like now. They cannot believe what the 4 majority decision judges are doing. It's 7 Democrat elected appointed judges. You're right. And 3 of them said this is a bridge too far. That's the first caveat. Second caveat, you all know it. This decision has been stayed basically indefinitely. I mentioned this yesterday, and I didn't say it not for nothing. Don't overreact. Don't despair. Don't get doom-pilled, black-pilled. There's a reason why they issue this ruling. What is it now? December 15th, 16th? I don't know, whatever it is. We're like 4 days before Christmas. The Christmas holidays are a time of year where people go through a lot of psychological distress in ordinary times. In the best of times, people feel lonely. They feel alienated. They feel isolated. A lot of people do like self-harming things during this time of year because they get depressed, etc. What better time of year to doom people into oblivion with this court order to say, not only are you now going to go and spend time with your family and fight over politics, but we're going to convince you that you are doomed, and we're going to try to take advantage of you in your moment of most despair to try to provoke you into something that you should not do. Don't do it. Take a deep breath. That's it. That's the warning again. But now I've read this decision thoroughly. We're not going to go through the dissenting decision because the dissenting opinions, because they don't say anything that is not common sense and basic logic. The majority opinion, the mental gymnastics that they had to go through in order to declare Trump ineligible, excluded under the 14th Amendment of the Constitution, 3rd paragraph, the mental gymnastics would make I can't think of a gymnast fast enough. It would have been good. It would make fill-in-the-blank name gymnast look like an old man who can't touch, his toes because he's so unflexible. Brian Boitano. It would make Brian Boitano look like my father in terms of the mental gymnastics that they had to go through in order to come to this ruling. I've highlighted a few of the paragraphs. It's so bloody long. I said it yesterday. Baffle them with bullshit. I'm going to read. Let me just take my glasses down again. Oh, God. No, this is not right. That's not the right decision because I'm well past it. Okay, here we go. Starting at paragraph 3, and I've highlighted this. The court found by clear and convincing evidence that President Trump engaged in insurrection, as those terms are used in Section 3. Bullcrap. How they had to get to insurrection? Because Trump was never charged with insurrection, convicted with insurrection. Nobody involved in January 6th was convicted of or charged with insurrection. So how did they get to it? Dictionary terms of insurrection. We'll get there. But the district court concluded Section 3 does not apply to the president. How did they get to applying Section 3 to the president when the district court, the lower court that they're overturning, said, yeah, sure, Trump engaged in insurrection, but Article 14, what is it called? Amendment 14, subparagraph 3 doesn't apply to the president? Don't worry, the mental gymnasts on the Supreme Court of Colorado found a way to get there. Therefore, the court denied the petition to keep President Trump off the primary ballot. And that's the conclusion. Oh, don't worry, by the way, because what's going to happen? This Supreme Court is going to find a way to read in insurrection to Trump, read in the office of the president into the 14th Amendment, subparagraph 3. But I just wanted to highlight. They're highlighting the gymnastics that they're going to have to get around to get to the order that they want. All right. Then we move over to paragraph 6. And it says, we are likeful mindful of our solemn duty. Duty. To apply the law. Bullcrap. Without fear or favor and without being swayed by public reaction to the decision that the law mandates we reach. Bull steaming crap. What this is a bunch of rogue justices prefacing their decision, setting it, framing it, laying the brickwork. They're the victims. While they desecrate the Constitution, shred the law, deprive people of their God-given right to vote for the candidate they want to, they've got to paint themselves as being the victim. It hurt us to do this, but we're going to do it anyhow, even though there will be public outcry for us basically taking a steaming dump on the Constitution. We're the victims. We're the noble ones here. We've got to do it despite all of this, and we're going to. Oh, it's just beautiful. The classic narcissist, by the way, makes the aggressor the victim and makes the victim the aggressor. Just think about that. Darvo. Deny, attack, reverse, victim, and offender. This is Darvo. These are sociopath, narcissist, pathological psychopaths on the judges. 4 people who order this. 3 other Democrats, not that much psychopaths. Even they couldn't get to this point in time. Okay. I hear someone coming in for the door. I will be out in 2 minutes, sir. Get out of here. Get out of here. I'm using your phone to record this video. Get out of here and I'll be up there in 2 minutes. Paragraph 173. This is amazing. Oh my goodness. When they talk about how they got to the conclusion that they got to, by the way, in terms of how they got to condemning Trump for insurrection, a criminal infraction in a civil proceeding. Look, I'm no doctor. I'm no American lawyer. I'm a former practicing Quebec attorney. How they did that is truly amazing. It's truly a work of judicial art, magic, if you will. They have condemned Trump to participating in insurrection, which is an actual crime. Sedition and insurrection are actual crimes under the Criminal Code, the United States Code, USC. They're in but nobody was charged with insurrection. No one was convicted of insurrection because no one was charged with it. That includes Trump. So how do they get to it? Well, they have to say he was, colloquially speaking, convicted or found to have participated in insurrection on the civil scale. How'd they do it? They found a way of incorporating the January 6th committee report, which itself reiterating the obvious. We've talked about this many times. It was an unlawfully formed committee. It did not have the requisite number of participants. It didn't have a bipartisan committee to it. It was an unlawfully formed, invalid committee that literally, and I mean literally, fabricated, edited, stylized evidence, synthesized evidence, deleted evidence. But this court, the Supreme Court of Colorado, found a way to creatively work in the report of the January 6th committee, including the testimony, hearsay testimony, of Mr. Meadows. You know his name because he's been named many times on this channel. Hearsay evidence from that January 6th report, going all the way to paragraph 173. Second, the report explains that Chief of Staff Mark Meadows told White House counsel Pat Cipollone that President Trump, quote, doesn't want to do anything, end quote, to stop the violence. The fact that this statement is hearsay is irrelevant. This is from the decision. I'm not making this up. And I'll quote that again. The fact that this statement is hearsay is irrelevant. The court expressly noted that, quote, it has only considered those portions of the January 6th report which are referenced in this order and has considered no other portions in reaching its decision, end quote. And it did not mention this statement in its order, nor did it rely on it to reach any conclusions. Thus, President Trump's embedded hearsay argument is unavailing. Oh, they didn't rely on it, but they referenced it. They didn't rely on that particular portion of what they recognize as being hearsay evidence, but they're going to incorporate other portions of the report of the biased, unlawfully formed kangaroo court of a committee. That's totally fine. It's totally fine. Okay. How did Trump engage in insurrection? Paragraph 176. I've highlighted this. I spent the entire day going through this decision. When I wasn't doing a podcast on the unusual suspects with Vinny Oshana and the team at Patrick Bet-David's Valuetainment, it was fantastic. When I wasn't on a Twitter space with Roger Stone before that talking about this, I was looking through this decision all day to highlight the best portions for you. Paragraph 176. I'll read the whole thing. President Trump challenges the district court's finding that he, quote, engaged in, end quote, unquote, insurrection, end quote. The Constitution leaves those terms undefined, but the law doesn't, because insurrection is an actual crime under the legal code of America. So it's not really a term that nobody really knows what it means, although it might be even ambiguous under the criminal code, the United States Code. It's a criminal infraction. But because he wasn't charged with or convicted of, well, now we got to go colloquial. Let's just go with the Merriam-Webster definition, because they do. Mindful of the deferential standard of review afforded to the district court's factual findings, this is my highlight, we conclude that the district court did not clearly err in concluding that the events of January 6th constituted an insurrection, not in quotes, and that President Trump engaged in that insurrection. That's the end of my highlight. Do you remember that portion of the lower court's decision where they said that Trump engaged in insurrection, but because the 14th Amendment third paragraph doesn't apply to the president, well, then we can't disqualify him from the ballot? Some of you might be thinking this is like 4D level chess, like the lower court said, well, I'm going to give what the upper court needs to overturn me, to say the Trump engaged in insurrection, but I've come to the legal determination that 14th Amendment doesn't apply to Trump, the president. But I'll give the factual finding to the higher court to overturn my decision. Bear in mind, people, for those of you who don't know this, and I assume it's roughly the same in the States, the appellate court, the higher level court, does not reassess findings of fact of the lower court, but they can freely reassess findings of law. So when the lower court, that judge, I think her name was Wallace, says, yeah, I find that Trump participated in insurrection, that's a finding of fact. But under the law, I don't believe that the 14th Amendment third paragraph of the Constitution applies to the president as a matter of law. The higher court can come in and say, okay, well, we're not going to contradict your finding of fact that Trump participated in insurrection, but we disagree with your finding of law, which is what they did. Whether or not this was like the four-dimensional chess game, I don't think so. I just think it's, you're playing chess, these are your pieces, what's your best move at this point in time? The lower court said, he participated in insurrection, but as a matter of law, I don't think the 14th Amendment third paragraph applies to the president. The next level court says, we're not going to reassess your finding of fact, but we're going to reassess your finding of law. The 14th Amendment third paragraph does apply to the president. Let's get there, shall we? All right, paragraph 181. Webster's third new international dictionary defines, quote, insurrection, end quote, as, quote, an act or instance of revolting against civil or political authority, or against an established government, end quote, or, quote, an act or instance of rising up physically, end quote. Insurrection. Webster's third new international dictionary, 2002. When you can't rely on the law, just go to the dictionary. Paragraph 182, this is what I highlighted. In light of these and other proffered definitions, the district court concluded that, quote, an insurrection as used in section 3 is 1, a public use of force or threat of force, 2, by a group of people, or 3, to hinder or prevent execution of the Constitution of the United States. Hey, spoiler alert, Supreme Court of Colorado and all you Democrats who love protesting in the streets during your summer of love, that applies pretty much to any protesting of congressional hearings, protesting of Judge Kavanaugh, for example, protesting of laws being passed, pertaining to Second Amendment or reproductive rights, as people like to call it. That applies to all of it. So congratulations, you now protest that, you are participating in insurrection. Just so you understand the precedent that you're setting, at least as my understanding goes. Let me go to paragraph 188. Finally, substantial evidence in the record showed that the mob's unified purpose, the mob, not Trump, by the way, the mob, but they're going to link Trump to it because of a tweet. The mob's purpose was to hinder or prevent Congress from counting the electoral votes as required by the 12th Amendment and from certifying the 2020 presidential election. That is, to preclude Congress from taking the actions necessary to accomplish a peaceful transfer of power. Except it happened 6 hours later, but just craziness. Can't read without my glasses. As noted above, soon after breaching the Capitol, the mob, not Trump, not nothing, and by the way, timing matters because apparently this mob had already breached the Capitol before Trump had even given his speech, whatever. The mob reached the House and Senate chambers where the certification process was ongoing. You hear that, people? You interfere with a certification process. Insurrection. Interrupt Kavanaugh. Interrupt Clarence Thomas back in the day. Interrupt Tennessee's Second Amendment right stuff. Interrupt whatever states are passing trans laws that people don't like and you protest and you interrupt those proceedings. Bam. Insurrection. Good luck ever running for president again. In fact, good luck ever voting for the candidate of your choice again. Understand it. Though you won't until it comes to bite you in the ass. That's the way it works. Circular firing squad is what it is. We go to paragraph 206. 206. And on January 1, 2021, President Trump retweeted a post from Kylie Jane Kramer, an organizer of the scheduled January 6 march for Trump, that stated, quote, "The cavalry," and I'm reading from the decision, sick. The cavalry is coming, and they put sick after the cavalry, as if to suggest that Kylie Jane Kramer meant to say the cavalry, and wait until you hear why. Mr. President, yada, yada, yada. The foregoing evidence that President Trump's messages were a call to his supporters to fight and that his supporters responded to that call. The cavalry is coming. Now, I remember reading this at the time. Calvary is a Christian religious term about the place where Jesus Christ was crucified. Cavalry means, people on horseback. I messaged the person who tweeted this. Her name is Kyle Jane Kramer. She might be coming on sooner than later for a live stream. It's no sick. It's no typo. She meant the cavalry. She meant a religious, symbolic framing of this. She meant something religious by this, not cavalry. In fact, I remember that being the explanation at the time during the impeachment. And yet this court, this sham, fraud, commie, 4 judges of the court said, cavalry, sick, as if to state, because I don't think this person testified during the trial, hence the importance of not allowing hearsay evidence in, statements made by people outside of court that you admit as evidence of the statement in court. If she had been called to testify, she would have said, get that sick out of there. I didn't mean to say cavalry. I didn't mean to say we were coming in on horseback to fight. I meant cavalry, as if to represent where Jesus Christ was crucified. No, but that's what they relied on, to say that Trump retweeted a call to violence. The cavalry is coming. I know what the cavalry is because when I was in Texas watching Alex Jones's sham trial, I went by a place and it said the cavalry. I was like, oh, that word looks funny. It was a church because it was the cavalry and not a typo for cavalry. They relied on the statements, these statements, which they then attribute, without ever having heard the individual, as far as I understand, to a typo. To then say, when she tweeted, the cavalry is coming, it was a typo, she meant cavalry. And when Trump retweeted her cavalry, it was a call to violence. This is what happened in court, people. Can I back it up and see what's going on here? That was cavalry, that was 206. Okay, then we go to 208. Listen to this. I tweeted this out today. People seem to appreciate the observation. I don't really think these judges, these 4 commie judges of the commie California, we're not in California, we're commie Colorado. I don't think they understand what they just admitted to in paragraph 208 of this decision. I'll read it, think about it as I say it, and then I'll spoil it by telling you what I think. Paragraph 208. Along the same lines, the Federal Bureau of Investigation, that's the FBI, received many tips regarding the potential for violence on January 6. One tip said, and I'm quoting from the decision, I'm not quoting from some conspiracy theory that told you this was a setup from the beginning, that intelligence knew what was coming because the FBI had already infiltrated the Oath Keepers and the Proud Boys months in advance, that they knew what was coming, that whatever her name is, Yogananda Pittman, had a memo circulating internally within the DC police. They knew what was coming. They remained understaffed on purpose. They refused to request the National Guard, knowing that if Trump imposed the National Guard, they would have called him, a usurper of power for calling the National Guard. It was a lose-lose from the beginning. Trump said and had offered. Kash Patel, during the trial of this very court case, said, "Yeah, we offered the National Guard. They never took us up on it." Had Trump imposed the National Guard, it would have been a coup. It would have been the coup, the militarization to remain in power that they were warning he was going to do that he never actually did. Listen to this. And I'll read it again along the same lines. The FBI received a bunch of tips, and I'm going to read the tip. This is one of them. They think they will have a large enough group to march into D.C., armed, and will outnumber the police so they can't be stopped. They believe that since the election was, quote, stolen, end quote, it's their constitutional right to overtake the government, and during this coup, no U.S. laws apply. Their plan is to literally kill. Please take this tip seriously and investigate further. So the FBI was getting tips in advance of the violence that was coming. Yogananda Pittman of the DC police force had an internal memo circulating as of December saying, "We know what's coming." The FBI and intelligence had infiltrated the Proud Boys and the Oath Keepers in their seditious conspiracy conviction. Infiltrated weeks and months in advance of the attack, the January 6th, and yet they were understaffed, and yet they didn't have enough police there, and yet they didn't call in the National Guard because they wanted this to happen. And had Trump unilaterally called in the National Guard, then it would have been something much more serious for Trump. That's what they said in the decision. I don't think they realize that this is evidence of advanced warning and advanced knowledge of the FBI. And I think that is the last citation that I have from this decision. They then get into how Article 14, subparagraph 3 applies to the president. They basically say, yeah, it applies to officers of the United States. And although that article specifically enumerates the officers to which it applies and specifically does not include the president, they say, well, technically the president is an officer of the United States of America. He pledged to uphold the Constitution. So even though other officers are specifically read into that and the president is not specifically included, we're going to include it nonetheless. So it was insurrection, not in the legal sense, but in the Merriam-Webster dictionary sense. Trump engaged in insurrection by retweeting tweets such as "the cavalry is coming." And by some just mental gymnastics, let's just say, Trump referred to himself as an officer, so therefore he acknowledges that he's subjected to Article 14, the 14th Amendment, third subparagraph. It's mental gymnastics of the most communist order, and it stayed, so there's no real impact of this. Some people are calling it a nothing burger because of the fact that it stayed. It's not a nothing burger. It's actually a very meaningful burger because it shows the degree to which institutions cannot be trusted to put country over politics. And the Colorado Supreme Court, overturning the lower court, which came to a different conclusion in law, has now set the stage for, where else do we have it? Minnesota, Michigan, I want to say New Hampshire. There's a number of other states where they're trying to keep Trump off the ballot, and the lower courts have rejected it for different reasons. They say the primaries are a party issue and not something that involves the states. But they're setting the precedent now to say that a state can disqualify a federal official on the basis of a federal constitutional violation at the state level. Try to make sense of that. This Supreme Court of Colorado has decided and set the precedent that a state court can basically make determinations for the federal criminal level, can in a civil trial come to quasi-criminal, if not criminal, determinations of exclusion. Because in order to be disqualified, you have to have participated in insurrection, which is a criminal offense. It's not a nothing burger. It's actually a very scary burger, but it's more like a scary steaming pile of judicial dog shit burger that everyone has to make sure don't overreact to. But don't let it fade gently into that night, because this will be used as the stepping stone for other states. In as much as the Alvin Bragg bogus persecution of Trump for the hush money alleged misdemeanors turned felony became the stepping stone for indictments in D.C., Florida, Georgia. This too will become the stepping stone, like that little domino in the meme that falls over, hits a bigger domino, hits a bigger domino. This will be the precedent that other states will now use to overturn the lower court decisions. The Supreme Court, I do believe, will get in and will set things right sooner than later, because this is absolute chaos. Some people are suggesting maybe the Supreme Court's not going to get involved because it's a state issue. No. You can't have a state disenfranchise the votes of every other state. Because that's what this is. If they basically say, a state says we can disqualify from our primary or general ballot a candidate based on a state determination of disqualification under the 14th Amendment, third subparagraph, that state is disenfranchising every other state and every other voter in America. It cannot be allowed to stand. I don't think it will be allowed to stand. How long have I been going for? 24 minutes? Holy crab apples. Well, I hope you've enjoyed this, people, because my wife is going to be very angry and my kid might not be asleep yet. All right, but we're going to end on a bit of a white pill. I always say, God, give me I can never remember it, the Serenity Prayer. A wonderful member of our locals community sent me a custom phone case with the Serenity Prayer. Look at it right there. God, grant me the serenity to accept the things I cannot change, courage to change the things I can, and the wisdom to know the difference. If I could just remember that, I think I would be a lot more chill of a human. I don't think I can be much more chill. If I could just remember it, I think I'd be a better person. And now I can, because it's on my phone. So Zara, thank you very much. vivabarneslaw.locals.com if you want to be part of our above average community. And what else? Rumble, Viva Frei, Twitter, the Viva Frei. I'll see you before Christmas, but Merry Christmas. It's the celebrating time of the year, and I'll be live tomorrow, but go enjoy the night. Now you know your vlog. Now you know more than 99% of the population as relates to this decision. Knowledge is power, and spread that power. Peace out, peeps.